This matter is before the court for the merits hearing related to a Public Records Act lawsuit brought by plaintiffs in this matter. Plaintiffs are represented by Mr. Thomas. Defendant Lewis County is represented by Mr. Eisenberg. I have reviewed all of the materials that have been submitted in this matter, and I am prepared to hear argument. I did say Mr. Thomas.
Your Honor, thank you. This is a quintessential Public Records Act case. These records that we're talking about here, and let the record reflect that I have in my hand all 3 transcripts that are issued in this case that were provided by defendants as discovery in June 2018 in this case. And we're arguing over these 3 transcripts today, Your Honor. These three transcripts were from cases decided right here in Thurston County Superior Court. I was the attorney, one of the attorneys, speaking in all 3 of these transcripts. Lewis County argues that these transcripts have some sort of privacy interest so that they cannot be produced under the Public Records Act. And plaintiffs argue today that Lewis County felt that it was unfair in order to produce these documents, and so they reverse engineered an exemption in order to prohibit plaintiffs from receiving these documents lawfully under the Public Records Act. I would ask this court to take judicial notice at this point that these documents are on the internet. There's declarations from each of the 3 plaintiffs in this action that these documents are on the internet and that they've seen these on the internet. And not only were these disclosed to plaintiffs, but anybody who has an internet connection could have downloaded these documents. In the meantime, these are public records. Not only were these done in open court where anybody could have come, in fact, there was a videotape of one of these hearings, which is substantially the same information as in one of these transcripts. But there are also transcripts on the internet. So let's get into the law. First of all, Lewis County has the burden to prove that these are exempt today under RCW 4256 550 Section 1, and plaintiffs argue that Lewis County hasn't covered their burden in this case. And I'll go over the legal reasons why. First of all, under FOIA, which is the Freedom of Information Act, which is a federal law, these documents are, Lewis County can't even argue today that these documents are not producible because under the public domain doctrine, materials normally immunized from disclosure under FOIA lose their protective cloak once disclosed and preserved in a permanent public record. In discovery, plaintiffs asked defendant if they paid for these documents. Defendant admitted that. Plaintiffs also asked if defendants had these documents in their possession. Defendant admitted that. Defendants paid for these documents, they have these documents in their possession, and in fact they produced these in discovery in this case. And so this meets the definition that these documents are, lose their protective cloak, they lose any exemption under the Public Records Act because they were disclosed and they were preserved in the public record. In fact, the declarations from the court reporters in this matter state that they were offered to plaintiffs in that matter. There was no secrecy, there was no reason to hide these. Plaintiffs had the opportunity to purchase them in these cases, and I think still would have the opportunity to purchase them. Lewis County's just offended because they don't want to comply with their duties under the Public Records Act. These are documents in the possession of an agency, they meet the definition, and they should have been produced under the Public Records Act. And once Lewis County disclosed these documents, they lost their protective cloak, they ended up on the internet somehow, and they are in a permanent public record. So that's the first point, is that Lewis County can't even argue an exemption because they're in a permanent public record and they lost their protective cloak because all 3 documents that are at issue here are in a permanent public record. So second of all, Lewis County argues that under the exemption of RCW 42.56.290, that the documents wouldn't be producible under pretrial discovery. That's wrong for a couple of reasons, but first, Lewis County says there's nothing that authorizes disclosure of these documents. Well, in fact, Your Honor, there is case law that transcripts are producible under civil discovery rules. And in fact, plaintiffs pointed to this court and demonstrated a case where in 1958, the United States Supreme Court said, you know, secretive grand jury transcripts are producible under discovery if you can show enough need for them. And as long as you meet that legal standard of showing enough need, those can be produced under Rule 34, which is substantially the same as Washington's Civil Rule 34. And so there's no argument there that these are not producible pursuant to civil discovery. Similarly, Lewis County argues that the statute, RCW 42.56.290, prohibits disclosure. However, they gave out every single document that is at issue here. This is the catalyst theory. It was because plaintiffs sued that they received these documents. This is what the Public Records Act is for. And because they received these documents, they are the prevailing parties today. And in fact, Lewis County is taking an irreconcilable position before this court because they're stating, on one hand, these documents aren't producible as pretrial discovery, but on the other hand, they produce them as pretrial discovery in this case. You can't have it both ways. They cannot be barred as pretrial discovery in every instance, which is what they're arguing. And on the other hand, they cannot be produced as pretrial discovery when they want to. They can't pick and choose. That creates an arbitrary standard, and the law wasn't meant to do that. The law is not meant to produce absurd results. And then fourthly, it is up to the Washington State Legislature to change the intent of RCW 42.56.290 because there's 25 years of jurisprudence construing the statute. In the reply brief, starting on page 7, plaintiffs outline the history of the Washington courts construing this. And in every single case that plaintiffs identified, the courts, Washington courts, in published decisions have construed this either as the attorney work product or attorney-client privilege. In Public Records Act cases, in the Cortland case that we identified too, Washington courts say, you know what, after so long, enough is enough, and we're not going to go back and revisit the meeting. Once we construe a statute, after enough time has passed, we're not going to revisit that because it creates confusion. And it sets the process, it upturns the process. And at that point, it's no longer for the courts to determine the definition, it's for the legislature to determine the definition. Your Honor, at this point, it is up to the legislature in order to change the law if they want to. The legislature could come in at any time and revise the statute if they wanted to enlarge it beyond attorney-client privilege and attorney work product. And they know about this. In fact, recently, Washington courts have started construing this and started calling this exemption RCW 42.56.290 as the attorney work product exemption. Washington courts refer to this as the attorney work product exemption in Seattle Times versus Serco, which is a Washington State Supreme Court case from 2010. And there's another one in the reply brief. But anyway, it's laid out in the reply brief. And so I will stop here and I will save the rest of my time for rebuttal. Thank you.
Thank you. Mr. Eisenberg?
Thank you. I think one of the most important things to remember when considering plaintiff's argument in this matter is that Lewis County claimed an exemption on these transcripts in 2017. And then in 2018, over a year later, in response to the filing of a new lawsuit, is the time at which Lewis County decided at that point that it was in its interest to produce these transcripts since they had been requested and named in the lawsuit as discovery in this lawsuit. So it's not the case as I believe plaintiff has sometimes sort of muddied the waters. It is not the case that we produce these around the time we claimed the exemption in lawsuits at that time, or that they were posted on the internet at that time. We're talking about things that happened more than a year later. The reason that's important is that the decision later to release the documents is a separate issue and can't be read to have occurred a year earlier and to waive things that happened a year earlier. That doesn't make any sense.
Well, I think you should focus your argument on what exemption could apply that would have made it appropriate for Lewis County to withhold the documents in the first place.
Thank you. So the exemption in question is the idea, it's a very work product-like idea. I don't believe that the work product rule specifically reaches these transcripts because although they were requested by a party in litigation, they were prepared by the court report. But there is a corollary rule to that which permeates CR 26, which is reflected in the declarations we got from other knowledgeable practitioners and court reporters in the state, that one party, when they request a transcript from a court reporter for their own pretrial preparation purposes, that the other party gets the opportunity to pay for that same transcript from the court reporter, but they are not entitled to simply take it from the first party as discovery in the litigation. They are not allowed to, quote, skate on the cheap, is Justice Alexander's phrase, by getting a free copy from what the other party already paid for. Now, there are several rules that outline that for transcripts. The rule relating to deposition transcripts says so explicitly. It says that the court reporter transcribes the deposition, and they keep the copy, and that then the party who ordered the deposition and paid for it gets a copy, and the other parties may have one upon payment of the fee. The same rule applies to video depositions. The same rule applies in federal courts. Basically, the uniform practice involving transcripts in Washington, and I believe in federal court as well, since 1980, when the court eliminated the requirement that all such materials be filed in court and therefore be public to everyone, is that you have a neutral custodian of the transcription, in this case the court reporter, and that each person who wants one gets it from them. They pay for it from them, as opposed to one party paying for it and then all other parties being entitled to have that copy. That latter situation, where one party pays and then everyone gets to share that copy, is explicitly the rule that applies in appeals, but it is not the rule that applies in pretrial civil litigation. The fact that there is such a rule in appeals explicitly, but there is no such rule, and there are rules outlining the contrary in civil litigation, is one of the reasons that Lewis County provided. Lewis County was very upfront with this claim of exemption. This isn't a circumstance in which it silently withheld or it changed theories or hit the ball. In the exemptions themselves, it attempts to articulate this exact point. And it talks about the difference between pretrial and appellate procedure. Lewis County also performed that distinction by trying to give out transcripts when they were requested, when the cases were on appeal, and it no longer appeared that any pretrial civil discovery protection applied. So it was attempting to be guided by the work product rule, the deposition rules, and the plain text of RCW 42.56.290, which doesn't refer to the work product rule alone or the attorney-client privilege rule alone. It refers to the rules for civil pretrial discovery in total. I understand that the cases that plaintiff has cited talk about work product, but that's because that was the civil rule at issue in those cases. In fact, at least one of them, perhaps Dawson or maybe Lindstrom, says it at least applies to these things. There's no exclusionary language suggesting that they meant it never would apply to any other things exempt. In fact, the fact that the attorney-client privilege is discussed as part of the same provision in some cases strongly suggests that it applies to all such exemptions from pretrial civil discovery, because that same statute that includes the attorney-client privilege includes a host of other privileges that apply in pretrial civil litigation, beyond the work product rule. This statute is not just a work product rule statute. It's referred to that way sometimes as a shorthand because that's its most common use. But by its terms, it says if an agency is a party to a controversy and another party makes a PRA request for documents relevant to that controversy, which they would not be permitted to get in civil pretrial discovery, then they don't get it. This was obviously a very thorny one, but Lewis County attempted to show that it had a very fully fleshed out legal argument based on several court rules and a lot of practice in civil litigation as to why these were exempt. As to why it made sense to claim such an exemption, there are several policies that underscore why one party should have to pay the court reporter for their copy. One of them is that it ensures compensation for the court reporters, so they'll do the work, which is reflected in the civil rules. And another one is so that, frankly, lots and lots of people are in litigation with government agencies. And if it is the case that they are permitted to have a free copy of any transcript paid for by the agency, even during the litigation itself, when that's part of the pretrial preparation, then other people that are suing the government are unlikely to order their own copy. They will instead get a free copy from the government, and that will increase the taxpayers' costs in ordering transcripts. I understand that that's a policy matter, but it shows that Lewis County's reason to claim the exemption was in good faith based on law, practice, and a good faith attempt to do what it's supposed to do, which is give out which records it should and keep those where the government has an interest and a lawful right to not give them out. Thank you. Do you have any questions?
I don't have any questions. You have 3 minutes.
Thank you, Your Honor. I don't even think that I'll use that. First of all, Lewis County's argument rests upon the fact that they're saying that plaintiffs somehow requested these as discovery. Lewis County had the burden to prove that fact in this case, and there's no evidence in the record whatsoever. In fact, if this court looks at Mr. Carter's declaration, which I think is Exhibit A to the response brief, Mr. Carter says something to the effect of, I can't even remember if these were requested as discovery in any of these cases. And so Lewis County didn't show any discovery requests. They didn't show anything that they alleged that plaintiffs had sent to Lewis County that encompassed these requests. The attorney who was working on all of these 3 cases says in the declaration, I don't remember if these, I think so, but I don't remember if these were requested as discovery. And so Lewis County doesn't carry their burden. Plaintiffs didn't request this. There's nothing in the record that identifies that plaintiffs request this. And so Lewis County's whole case is rested upon, their whole defense is rested upon that plaintiffs requested this in discovery, and they're saying that it's not fair for one party to pay for it, and the court rules prohibit, the civil court rules prohibit one party paying for it, and then another party getting it for free and using it in the Superior Court. But it was never used in Superior Court. It was never asked for its discovery. There's nothing in the record that identifies that. And in fact, Lewis County's attorney, who is identified in all 3 of these transcripts as the attorney of record for these cases, can't even identify when they were asked for his discovery in those cases.
Thank you. This matter is before the court for the merits hearing in this case. This relates to 3 requests. An April 14, 2017 request for a transcript from a March 3, 2017 hearing in front of Judge Dixon under case number 16-2494134. The next request was May 3, 2017, requesting a transcript from April 21, 2017. That hearing had been in front of Judge Lanise in case number 16-2396034. And the third request that is before the court today was made on May 15, 2017, requesting a transcript from a May 5, 2017 hearing, also before Judge Lanise and in the same case number as the previous request. There is no dispute that Lewis County had ordered the official transcripts at its expense and had them in their possession. The dispute before the court is whether I think there's a dispute as to who made the requests, but I'm not addressing that issue today. But whether or not the they were properly not provided. And ultimately, Lewis County has now produced those transcripts on or about June 7, 2018. And what they indicated, they were providing it as discovery in this case, and incidentally to stop the clock on any potential penalties that may accrue if Lewis County is deemed to have incorrectly claimed an exemption on these 3 transcripts. I hereby submit to you for your client's benefit the 3 transcripts you sought in the requested issue in this case. And of course, the exemption that was sought by Lewis County and has been argued by both counsel is RCW 4256-290. As was appropriately argued by Mr. Thomas, the standard for the purpose of this hearing, the burden of proof, is that Lewis County must show that the records are exempt from public inspection, and that's RCW 4256-550 subsection 1. Lewis County has made multiple arguments that all circle back, I think, to try and support why these records would be exempt under RCW 4256-290. And that states records that are relevant to a controversy to which an agency is a party, but which records would not be available to another party under the rules of pretrial discovery for causes pending in the superior courts are exempt from disclosure under this chapter. I would indicate that I agree with Mr. Thomas's argument that I don't believe that this record supports that these were requested in pretrial discovery, because the information provided by the Lewis County lawyer is unclear on that issue. But I'm going to go further in my ruling rather than just look at that issue. Lewis County argues the exemption from pretrial discovery and cites Civil Rule 26B1A. The frequency or extent of use of the discovery methods set forth in Section A shall be limited by the court if it is determined that A, the discovery sought is unreasonably cumulative or duplicative, or is obtainable from some other source that is more convenient, less burdensome, or expensive. The county cites this provision repeatedly and provides numerous declarations making legal conclusion that that section somehow applies. The county shows that any person can obtain official transcripts themselves by ordering them and paying for them, which is true. The county fails to show, however, that having the requesters in this case obtain the transcript from another source, specifically court reporters, would be 1, more convenient, 2, less burdensome, or 3, less expensive. The county does not show that it would be unreasonably cumulative or duplicative. In fact, it would be less convenient, more burdensome, and more expensive for the requesters in this case to obtain the transcripts from a court reporter, and this argument fails. Lewis County argues exemption really, as they continue to argue the pretrial discovery issue under the statute, under rules that apply to court reporters. The county cites and analyzes numerous laws that govern how court reporters handle transcripts. They cite CR 28, which was discussed in argument, and that relates to transcripts of depositions. CR 30F, how court reporters certify deposition transcripts, and CR 30B, which is expenses for videotaped depositions. None of these are an exemption that relates to this case. I appreciate the county's argument that it's akin to those rules, but those are specific rules that outline specifically what should happen to those documents and how they should be handled. The transcripts from the hearings in Thurston County don't fall under these 3 sections. Lewis County cites rules regarding transcripts on appeal. That does not apply to this case as well. Finally, Lewis County argues that custom prohibits litigants from giving an official transcript to an opposing party because doing so would be unfair to court reporters. Well, first of all, I don't disagree with that argument in general. It is unfair that a party can it is potentially unfair that a party could get a copy of a transcript without paying for it. And certainly, court reporters should be paid for their work, and their work is valuable. The county provides ample evidence that it is custom to not share official transcripts with opposing parties during pretrial discovery. They provide sound policy reasons that support this custom, namely that court reporters, again, should be paid for their work. However, the county fails to show that this custom is embodied in the law, and it's the law that is at issue in this case. Custom alone is not a reason to restrict access to public records. I'm going to state what both lawyers in front of me have heard and argued probably multiple times. The Public Records Act shall be liberally construed and its exemptions narrowly construed to promote this public policy and to assure that the public interest will be fully protected. The PRA clearly is a mandate for disclosure, and there are very few documents ultimately that are protected from exemptions and disclosure under the Public Records Act. And so the argument as it relates to custom fails as well. These records are not exempt under RCW 4256-290. They were improperly withheld by Lewis County, and I rule in favor of the plaintiffs on the merits related to this lawsuit. The court now needs to set a penalty hearing, and at that time the court will address the issue as to one of the contested issues that I did need to get at today as it relates to whether or not the PRA was violated. It was violated. I've made that finding. But there is an issue that Lewis County, I believe, wants to raise as it relates to who made the 3 requests, and they can do that at the penalty phase, along with the court hearing from plaintiffs as to what they believe are the appropriate penalties, and addressing, of course, the factors that the court will need to address as well. I'd like to go ahead and set that hearing today while the parties are present. I'm going to set it in early January.
Your Honor, could we have more time in early January?
Yes.
Would it be end of the month, end of January, or early February be acceptable to this court and to the defendants?
Yes, I just didn't want to put it off too far, which is why I said January. Do you have a proposed date? And I can look. February 4th at 1:30 would be open.
I just asked because the defendants said that they wanted to do some discovery, and we would have to.
February 4th, Monday, February 4th.
I'm sorry, I'm looking at, thank you for saying that, I'm in the wrong month. I was in January. So let me look again. February 15th is available at 1:30. Do you believe that that will give you sufficient, I'm asking both parties, will that give you sufficient time to address the issues?
I think so, yes.
Yes, Your Honor. And you said that was at 1:30?
That'll be at 1:30.
Thank you.
So what I need to do today is sign an order that sets the hearing on penalties, and that identifies the two issues, the issue of who will be entitled to the penalties, and then amount that could be, and then amount of penalties. Judge Price is taking over my caseload as of January 1st, and so he is the one who will be hearing this case. I think it will be important that we enter an order from the hearing today, prior to that hearing, so he knows what happened at this hearing, and that I ruled obviously in favor of plaintiffs. And so I would like to do that. I would allow you just to submit a proposed order. I would have plaintiffs submit a proposed order, and then defendants can simply provide any objections they have to that proposed order. I'll work off of plaintiff's proposed order, however.
Would it be okay if we do that electronically today? Or would you like that in writing, or in written delivery to this board?
Well, I will need, you can email it to my judicial assistant. Is that what you meant?
Yes, that's what I was asking.
Okay, yes. I don't want to set another hearing to get this order entered, and I'm not going to make you come back for an extra hearing.
Just to clarify, I wanted to go back to my office and then type it up and email it to.
That would be, why don't you email it to Mr. Eisenberg? You can also email it to my judicial assistant, and then Mr. Eisenberg, if you would have any objections by next Friday, and then I will enter the order. And I would ask that my clerk then set this matter over to December 14th, please. But set it over just to my civil motion calendar. You don't need to come, but that is what will prompt me to ensure that I get the order entered. You're going to email it to me, but I have many cases that I'm seeing, and I want to ensure that I get the order entered. And so I'm going to have it appear on the calendar knowing that no one else is going to appear, and I'll enter the order. I may do it before the 14th, but I will enter it no later than the 14th. Thank you.
Thank you, Your Honor.